Hello, good afternoon, and welcome to The Law. This is your Legal Lights. It is your health law. It's an interesting discussion this afternoon, and very many of you are interested. In fact, you provoked this discussion on social media, beginning with Abdul Hai Moment test or post, asking the question how they feel annoyed when they park their cars at the restaurants and at the hotels, and there's that bold sign that says, "You park at your own risk." Why? Okay, what is the legal effect of such disclaimers on premises? I've got the best to help you with platinum legal advice. We'll be right back. You're welcome back. This is The Law. It's your Legal Lights. It's your health law. And today, once again, we are privileged to be hosting Atakra and Atakra. Yeah, I mean that. You encountered them, let's say not too long ago, but so long ago. Jude Atakra Tufo and Kweku Atakra Jumo. They are both private legal practitioners. They are lecturers of the law. Jude teaches at the Central University, and Kweku also teaches at the UPSA Law School. And if you remember, they are the authors of this book that is, when we talk about contracts, as in sale of goods, Atakra and Atakra on sale of goods. So the last time you were here, you told us everything we needed to know about our duties as when we are selling and our duties as buyers when we are buying. And the fact that that is a contract between us, if you are buying, and the seller. You didn't tell us that when we are parking our cars at restaurants, or when we are taking a ticket and it says see back, and there are some, implications there, will be affected. So today, that's what we are trying to look at. So let's begin generally, because we're focusing on driving onto the premises of places. The right place to seek refuge will be occupiers liability. What exactly is that? Jude or Kweku, any one of you can take it up. What exactly do you mean, lawyers, when you say occupiers liability?
So generally, when we talk about occupiers liability, we are referring to an occupier of premises. And first, we need to understand who an occupier of premises is. That is basically someone who is in physical actual possession, someone who is in control of a particular premises, or someone who has legal control.
So, go over that again.
Someone who is in physical actual possession.
Physical actual possession.
Where the person is in control.
Okay, so of the premises.
Of the premises. So the person could be an agent instructed by an owner of the premises.
Oh, right.
Or someone who has legal ownership.
Legal ownership
of a premises.
Of the premises.
Yeah, so I'm saying this because there have been instances where the court have actually handed down certain sort of punishments to legal owners when the premises were not actually being controlled by people in actual occupation.
Okay.
Right. So basically, as an occupier of premises, the law requires that you provide some common duty of care to those who come onto your premises. That is to make sure that the premises are a safe place for those who come. In Ghana,
I own a shop or I'm operating a shop. I own a restaurant, I own a hotel, or I'm operating the hotel.
Right.
I have certain duties towards the people who will come in there.
Very well.
All right.
Yes. So basically in Ghana, let me just put this on record. In Ghana, the laws that regulate this area is basically regulated by the common law. We don't have any specific statute regulating this. But it's also important to, right from this point, we also need to explain that we are looking at the public space and the private space.
Right.
Because I know that your discussion basically started with the public space.
That's right.
I'm saying this because I'll eventually make a point, which is basically within the public space, but not within the private space. And so basically, as an occupier, like I was saying, provide safe place for those who come onto your premises. That is a basic duty you need to provide.
All right.
The common law provided certain categories of people who could come onto their premises, such as an invitee, a licensee, a trespasser, and also someone who was under contract to be on the premises.
An invitee.
Yes.
A licensee.
Yes.
Then
someone under contract.
Under contract.
Yes.
Trespasser.
And a trespasser. This is
4 people who can come over there.
over there. These are
the
the
premises.
Yes. So this was how the common law looked at it, generally.
I'll say, hold on there.
Right.
So you can see clearly from the beginning that it's going to be a very interesting law class. And all of you who indicated that you're going to be tuning in and listening, start listening and listen well. If there's a premises, a person who has control over the premises or has legal ownership or has actual possession and control of the premises, there are duties that they are supposed to exercise towards the people who will come in there. And there are 4 classes of people who can come in. He has named them. We'll deal with them one by one. Yes, Kweku, what do you have to say? Sort of in addition and in further elaboration of the general point of occupiers liability.
Okay, so the concept of occupiers liability, and let me explain it, let me give just a background insight to it, just for your listeners. Now, when you take a doctor, for any doctor, when you have a patient given to you, there's an obligation imposed on the doctor to exercise due care to ensure that he gives the patients the right and best treatment. The same way with the lawyer. When the lawyer is handed a brief, there's every duty on you to execute the task on that brief with all the diligence, with all the care. And so you see that some lawyers may be hauled before the council for probably exercising their duty negligently. In the same way for occupiers of a premise.
And people can actually be sued.
Yeah, people can be sued.
Lawyers,
yes,
for negligent advice.
Exafojo and law chambers and all that are clear. So in the same way with a premise also, anybody who runs a premise, if you're inviting people to come there, there ought to be obligations imposed on you so that if you don't treat the people well, and I'm using treat loosely, or if you perform your task in a manner which causes harm to that person, there should be a way of holding you liable. So that's the entire concept of occupiers liability, that obligations must be imposed on persons who are owners of premises. And you rightfully mentioned that we have to create a dichotomy between the public space and the private space. Said that, and your examples you give are all those in the public space, that there should be some obligations placed on the owners of the premise so that when private users use the place, they can be assured of some level of safety. Because it don't make sense that you invite me to come to your place, but you tell me that I can't protect you. And that's where this whole concept of occupiers liability come in. And as, again, he rightfully mentioned, in Ghana, in some jurisdictions, there are specific laws on occupiers liability. So in UK, they have an Occupiers Liability Act of, I think, 1957 with an amendment 84. In Kenya also they have, but Ghana we don't have. So it means that we still rely on the old common law rules, which he mentions.
He said common law. You say common law. What's common law? That's the question you're asking, right?
So okay, if you take that one.
So common law, most often than not, we, of course, they form part of the laws of Ghana under the 1992 Constitution, Article 11 specifically. However, the provision in our Constitution only focuses on received common law. The received common law, which basically flows from the laws that had been received as at the time most of the general statutes of the English laws were being applied in Ghana, and the laws that we had also relied on until we passed certain laws.
All right.
However, when we refer to this particular common law, it doesn't form part of what is in Article 11. Because this particular common law we refer to is in respect of persuasive common law. So that is what we need to understand. Of course, we can say common law is judge-made law. Common law is, there are laws which are based on judicial precedent.
Great.
But that differentiation must be created. This common law we are referring to has nothing to do with the laws of Ghana.
Right.
It's a persuasive common law.
Great.
Yeah.
Thank you very much.
And just to add, I mean, and basically we're talking of the common law, we're talking of the rules which are applicable in England, which became, some of them became part of our laws.
That's right.
But as it stands, they don't have a binding authority, as I was saying, that they are of persuasive effect before our courts.
Great. So can we move back to the 4 classes of people? Then we will use that to segue somewhat into the public and private premises. Right. Yes.
So as was rightly indicated, so we have the those basically subject to contracts, the invitees, then we have the trespassers, and we also have the licensees. Okay? So the major problem with the common law was the differentiation between the invitee and the licensee. So for instance, assuming you and I walked into a bank, okay? So I'm probably following you for you to go and cash or withdraw or whatever it is. I am not a customer of the bank, but you are.
Okay.
You enter the bank, but because if you enter and something happened to the both of us, because you are the customer, you are deemed to be an invitee. I am just deemed to be a licensee. And the obligation imposed on the bank towards me is lower than that towards you. Okay. So that was what the common law created, and this was a gap. Okay? So basically, so what the common law tried to do was that, and by being an invitee, there was an implied invitation position on my part. By so doing, what was the bank supposed to do? Were they supposed to put warnings there? Were they supposed to inform me? What was your obligation towards me? And this is what the common law hasn't been clear about. There have been instances where the common law's approach has been that basically, if this is a practice known to the particular occupier, then what you need to do is that you need to issue out enough warnings to those occupiers so that when certain things occur to them, then their liability will not be positioned. Other than that, failure to do so would mean that the occupier would be liable for any damage or any problem that occurs to that particular invitee or licensee.
And remember, as explained from the start, the occupier is the one who has the actual fiscal control, possession of the premises, or like he said, also has legal, as it were, legal ownership of the property. So hotel, restaurant, he just mentioned the bank. In a bank, like you said, when I enter my bank, I am an invitee.
Yes, that's it. Yeah.
Because I'm a customer.
You're a customer, that's
the bank expects that I will come there.
Exactly.
But I could be entering first time. I'm not a customer.
That's it.
It is naturally expected that I would come into the bank to want to do business.
Yes.
So I would be a licensee.
That's it.
And why should the duty of the bank towards me, the customer, be different from the one who just accompanied me there or the one who just entered there?
Okay. So now you are introducing the problems, that the inherent problems in these distinctions.
All right.
Now let me just go through them to give what they are, like in just layman terms.
Right.
Now the contractual entrant definitely is a person who has a contract with the occupier of the place. So it could be an employee, or it could be somebody who has a contract with the person, so the person can use that premise.
Right.
Now the confusion comes in usually with the invitee and licensee. Now the invitee is a person, he doesn't necessarily have a contract, but the occupier has a material or financial interest in that person. So he has no contract with the person, yes, but then the occupier has some level of material or financial interest in that person, as opposed to a licensee where he has an implied permission to be there, but the occupier has no financial or material interest in him. So the example Jude gave, you'd have that instance where two people walk into a bank. One is a customer, the other is not a customer. Probably I follow him as my brother.
You're right.
Now the bank has a financial interest in him because his money is there, or their money is either ways you look at it. Right. But for me, they have no interest in me. Now this category will say that it will want to confer on me the status of a licensee, but confer on him the status of an invitee. Now touch wood, we enter the bank and something falls on our head equally. The bank's obligation towards him will be that because he's an invitee, the obligation should be different from me, also a human being, just because I do not have any, they don't have any material interest in me. They'll say that I'm a licensee. And that's where the challenge comes in. Okay. For the trespasser, it's clear. It's the person who you don't have an authority to be there. So you have some place, they'll indicate that, let's say, nobody should come in here after 6 p.m.
Right.
If you go there, you are clearly unwelcome, so you are considered as a trespasser. So the challenge you mentioned...
For which the occupier has no any responsibility towards you.
Even not necessarily. Not necessarily, because if we go through, you see that with the trespasser, there are still some obligations towards the trespasser. The main difference may come in the threshold of liability. So probably when it hits Jude's head as an invitee, maybe their obligation towards him will be more than me. So probably they may compensate him just loosely. About 100,000, they may find some 2,000 on me because the scope of the duty of care and the standard of care may be different.
Right.
And that's what brings in the inherent
Like you
injustice
started with the analogy of the doctor.
of the doctor, exactly.
When a patient is given to them, there's a duty to take care of them well. Okay.
Yes, exactly. So because he is the darling of the bank, because he's an invitee, the common law will impose that the obligation of the bank towards him is higher than me. And in fact, if you read the common law literature, you would see that for invitees, they say that the occupier must protect him of risk he knows of or ought to know of.
Risk that the occupier knows,
and those
or he ought to know.
Yes. So it means that he should be protected, so the obvious risk and the risk that they should know. But for me as a licensee, they only be liable for risk they knew of. So let's say that if the place was shaking, they probably had not seen it actually. They'll just say that, okay, too bad for you.
This place is safe for you. and the law invited you in here. Thank you.
In fact, before we came, we had this discussion now. So we didn't park on your premise. We parked somewhere. And my question to him was that...
Park the Society General.
Yes, at the bank. I saw you.
And my question to him was that, are we invitees or licensees? Because you have invited us.
Right.
If anything is to happen, so what would the bank say? Do we have accounts with them? They may say no.
Right.
They may say that, okay, we have no obligation towards you. But, it's just like, we are talking of just about a 5 or 10 meter distance.
That's right.
Yes, but then those legal frictions are created, which in other common law jurisdictions, like in UK and Kenya, as I was saying, they have moved from these distinctions.
Because they have put it in black and white law.
Exactly.
Okay.
There are laws that, if a word now, they categorize people as either as visitors, lawful visitors, or unlawful visitors.
Okay.
So whether you are an invitee, whether you are a contractual visitor, whether you are a licensee, you move under a lawful visitor.
Right.
Then the unlawful ones are trespass, which makes everything easier.
Thank you very much. We are interacting with Atakra, and Atakra, they are responsible for this brilliant work, legal work on Atakra and Atakra on sale of goods. So the first time you came here, and we're going through, the duties of the seller and the buyer, and I told you there was something I caught and I was going to use.
I remember.
I've actually used it.
Jalian.
I've actually used it. I've used it in court, but we are not going to share the fees. Right. So take note of this. We are asking the question, what is the legal effect of disclaimers on premises? Because you began this on social media by asking how you feel annoyed when you drive into a hotel, you drive into a restaurant, you drive into a shop, and you are parking and there's that sign. A sign like this one. Look at it. They are not as elaborate as this, but we can use this to show you how some of those signs look like. A sign like this. Park at your own risk. Management will not accept responsibility for any damage, accident, or losses. What is the effect of these kind of notices that you go to these places that you see? This other one, park at your own risk. The space is provided for your convenience. The company assumes no responsibility for loss or damage to parked vehicles. Now, Jude began to make a distinction with private and public place. Why is that important?
I had to make that point because, to an extent, Ghana sort of has provided or made provisions to regulate the area of public space through the Insurance Act of 2021, I think at 1051 or so, specifically in section 214, where the law requires that, the law actually mandates that public places are mandated to procure an insurance policy for third parties for damages or losses that may come to them. Okay, so that is why I made that distinction. On the other hand, whether private persons, whether if I own a home or a house, I'm required to procure such policy. Those things have not been provided, and because we also don't have an occupiers liability law, it creates that gap or that difficulty. So that is why I had to create that. To an extent, within a public space, that has been done. But how does that fit in with these clauses or notices that you just showed to us. So that is where the challenge is in terms of contracts, in terms of negligence. How do we deal with it? So the starting point is that when we look at these notices, the first thing that we need to consider is whether these notices are reasonable or whether they have been brought to the attention of the particular, whether lawful or unlawful visitor. Has it been?
Please note that because that is very essential in the law we are discussing. Reasonable or they have been brought to your attention. Either the notices are reasonable or the notices have been brought to your attention. These are two important things.
Right. Yeah. And whether the notices have been brought to your attention or they are reasonable, so the court basically, or the approach is that we'll have to find out. So in terms of what is meant by reasonableness, there are some notices where they are deemed to be contracts upon contracts. So for instance, I go into a hotel, I have booked in, I have paid, I have signed on, I enter into the hotel room and I see these notices. They are deemed to be a new contract, which have been prepared onto another contract. Okay? So these new contracts, because they are deemed to be after contracts, they are usually deemed not to be contract that can be relied upon. Okay? That is one. The other is notices where the inscriptions are so small that it is difficult. For instance, and you find them in ticketing. Okay? You are issued with a ticket, and you find these notices usually at the back. You get your tickets, and you probably been put it in your pocket. You don't look at it. So was it brought to your attention that
I really don't expect that a ticket could be a contract for me.
Exactly.
So what's the obligation for me to turn back? And so my failure to turn back and read those small notices then makes me liable by myself. How?
So that is where the issue of reasonableness comes in. If you're unable to bring it to the attention of the person entering your premises, then it means that you cannot rely on those particular notices that you put out there.
All right.
Then, so we have the contract issue, we have the lack of notice, and we have where the inscriptions are too small, and that because they are too small, it was unlikely or unreasonable for one to have looked at.
As if it was intended to be hidden.
Exactly. So those are the main issues in terms of...
You gave one example that I enter into the hotel, I go through the reception, finish everything, which means I have entered into a contract.
Right.
Then I get into my room, and then I begin to see these other disclaimers.
Disclaimers, yes.
And you're talking about contract upon contract.
Exactly.
So if this was not brought to my attention at the beginning, and then I go in, how can I be bound by it?
So that is what we are saying, that technically, or the common law position is that if you find yourself in those positions, you are technically not bound by it.
Okay.
Legally, you are not bound by it. Because these are issues that came after you had already entered into a contract.
Right.
If this had been brought to your attention at the time you were entering into the contract to go to that hotel, that would have given you the opportunity to determine whether indeed you want to be bound by these
So they
clauses
generally act as your exclusion clauses or exemption clauses.
Exactly.
So I should know them aforehand.
Exactly.
So I determine whether I want to go into the contract in the first place.
That's it.
All right.
Right.
So Kweku has been itching to say something about this. Yes.
Okay, let me start with the last point on the when you are made aware of the exclusion clause after you've entered into a contract. But there's a specific case that discusses that, not to sound too legalese, but Oli and Marlborough Park Limited.
Okay.
Now, in that case, for instance, the husband and wife they went to a hotel. They engaged the reception, paid their money, entered into a contract to use the hotel for a period. Now, when they entered into the room, they realized that they had been written there was an inscription there saying that all your properties are at your own risk. The hotel bear no liability and all that. The woman ignored it, went out. She left her key with the reception, went out. When she came back, somebody had taken the key, gone to a room, stolen her purse. The question was whether the hotel was going to be liable. Now, the court held that, and the court, in discussing the whole concept of disclaimers, held that notice was not brought to attention before entering the contract. At the time of entering the contract, all she knew was that she was safe in the hands of the hotel. So to spring up an exclusion clause later to say that your goods are at your own risk was unreasonable in the circumstance. There she may qualify as a contractual entrant. So the hotel has every obligation to ensure that she's kept safe together with her properties. So her hotel is held liable. Now, this whole concept of disclaimers comes up as an exception to the a defense to the occupier liability issue. But then the legal position is that with disclaimers and exclusion clause, they are determined under contract law. So by merely putting up a poster to say that, or just as you showed on the screen, all goods are at your own risk, the question is like this one. The question is that, does it amount to a contract between the parties?
It's an important question I was going to ask you.
The answer may be a no. And you see...
It's not the answer, it's a no. Maybe a no. All right.
The answer may be a no. And I'm saying that because, you see, that if you look at the trajectory of the common law, they try as much as possible, or the common law tries as much as possible not to make the occupier free from liability, especially when you have invited people to come onto your premise, or somebody comes to transact with you. And so, with instances where you would have, say, you purchase a ticket, and you see that it's written at the back of in front that see the back for conditions, and sometimes they're in small print. The court have held that that does not amount to a contract, and that does not exclude or exculpate the occupier from liability. In fact, there's a decision, I think Thornton and something by His Lordship Denning, where he said that if the parties or if the occupier wants to put such inscriptions on such ticket, he must bolden it or put in red print and put arrows by the side indicating that take notice of this. So it's to create a situation where the visitor should be aware of that condition and should take a decision whether I want to be bound by this or not. But merely putting an inscription somewhere may not be enough to exculpate the occupier from liability.
In other words, Jude, if those notices actually do have effect, they have a legal effect. Is that it? From the explanation that Kweku just gave.
Whether those notices have what?
A legal effect.
The notices actually have they may have a legal effect depending on... They may have a legal effect depending on the facts of a particular situation. Okay? So Kweku gave an example, or he relied on the case of the Thornton and Shoe Lane parking. There are other instances. Let me just also reference a particular case. Is it Tomlinson versus, is it one of the borough councils in the UK? Where a gentleman went onto a premise, and there was, so he went, it was a park, and there was also a lake by the side, and the position was that, eventually he actually jumped into the shallow part of the lake and injured himself. He brought an action, and the position was whether the park, that is the local authority, was liable or otherwise. The issue before the court was that he entered as a visitor, but there were signs and there were warnings that do not go to this part of the premises. If you do go there, you are going to find yourself, if you don't go to this part of the premises. He went there and injured himself.
Right.
So the extent to which these notices can become legal or binding is where, for instance, the risk or the problem actually moves from an area where you have been told not to go there to an area where you've been asked to use or go there. So for instance, if I enter a premises and they tell me not to go to this particular site because they are full of reptiles, okay, and that I should use this particular path. And whilst using the path that I've been given or the path that I've been authorized to use, I find a reptile attacking me, okay? That signboard or that notice cannot be used as a basis to exculpate yourself from liability. So that is basically what it is. So you are looking at the facts and the circumstances.
Right.
So what has happened in this particular instance? What are the issues involved? Then you can come to the determination whether you can rely on it or otherwise.
So from the point where you ended, it would mean that if the occupier made the notice bold enough, obvious enough to me, and I got to the place, I saw it, and then I went ahead, then it means I have accepted the risk the occupier says I'm likely to encounter.
I'll not necessarily answer as a yes. And you rightfully pointed by me saying that I kept saying may.
Yeah, that's right.
That's because under the law under occupiers liability also has a concept called warning. Now, warnings in tort law do not necessarily exculpate the occupier. And so that's why I kept saying that he may. So these notices may amount to a warning, or depending on the wording of the notice, may amount to a warning. Now, the warning is just, and let me just take us back a little to the classroom just to explain. Now, in the occupiers liability, you have to show that the occupier has a duty of care towards you.
That's right.
You must show that he has breached that duty. That's where we can say there's a liability.
Okay.
So in this regard, if it's established that you are whether a licensee, an invitee, or a contractual entrant, we establish that he has a duty. Now, whatever happened to you, whether they broke into your car, they stole whatever, it will be a question of whether there's been a breach of that duty.
Okay.
Now, for he or she, the occupier, must show that there was no breach. Usually, that's where they put up these notices to show that we put up this notice to indicate to you that you're on your own. Mm-hmm. So the question is that has there been a breach? There are lots of factors the court will take into account. One of it was whether he gave you a warning, of which the warning may not be enough to say that just because they gave you a warning, he's off his duty. And that's why I keep saying may.
Jude had mentioned and you had confirmed earlier that it must be reasonable.
Yes.
And it must have been brought to your attention.
Yes.
And it should not have been brought to your attention after you have entered the premises, but just when you are entering.
Yes.
Right.
Yes. Yes, I'm saying, but they form part of their comprehensive factors. Because for almost every case also it's treated on its merit.
That's right.
Because, I mean, depending, and in fact, the bigger problem comes in with the type of person you are. I mean, let's not forget that.
Right.
So we are trying to apply a common standard. But
the visitor,
standard
the licensee.
Yes. So the standard may apply to Jude, who may be an invitee in the bank. Same
invitee,
fact,
yeah.
Invitee will be different from me. And that's why I keep saying may. So maybe for him, the warning may be enough to say that there's been a breach. But for me, the warning may not be enough. And that's why I keep emphasizing the fact of a may. So it's a number of factors. In fact, even the amount of money involved in keeping the place safe is a factor to be considered by the court. Because there's a particular case where it was a hotel. I think the visitor was drunk, went onto the window, and he fell off and died. And the question was whether the hotel had been liable. The court, in assessment, looked at how much it's going to cost to make the place safe. So it determined that just about £8. So looking even at the cost factor, the court held that no, the hotel had been negligent in its obligation keeping the place safe. So a number of factors come in. I mean, I'm not sure will be enough for us to discuss the entirety of it. That's why I keep using the word may on the disclaimers. But the mere fact that the occupier, the hotel, the restaurant, whatever, they have put up a notice saying we are not going to be liable, may not be enough. And I shared a story with Jude. There was a case where a person went to a bank. No, was it a bank? I think it was a bank, yes. He went to a bank to deposit money. Now he parked outside the bank. He didn't park at the banking premise. Now he went into the bank, attempted to deposit money, and they told him to bring something else, I think a particular document. So he went into his car, deposited the money in the car, and left, went to a place nobody knows. By the time he could come back, somebody had broken into the car. The question is whether the bank would be liable. Again, we'll go through the same rudiments. Is he an invitee? Is he a licensee? Did he engage in an obvious risk? Because the occupier has no obligation to safeguard against an obvious risk. So did he engage in putting money in your car, parking probably by the roadside? What did you expect? So in that regard also, the occupier may have a defense. So as I'm saying, it encompasses a number of factors. But at least we can be safe to conclude that merely putting up a disclaimer may not be enough to exculpate the occupier from liability.
Jude wants to say something.
So in fact, just to add that the courts are very strict when it comes to these disclaimers and these warnings and these exclusion clauses. That they try to ensure that whatever it is, especially if you are looking at certain categories of individuals, particularly children, when children are involved, the courts are very strict. Because the argument is that children are less likely to be cautious or careful as compared to young adults and also, how do you call it? And also children who are probably up to the age of 18. Okay, so the court normally use the expression when there is an obvious allurement within a premises, which are likely to induce children to go to those premises. We expect you to take extra care in addressing those issues to prevent children from getting into these premises. Okay, so when it comes to children, the courts are very strict. Okay.
You're still here on the law. It's your legal lights. It's your health law. We are looking at occupiers liability, legal effect of disclaimers on premises. And my guest, Jude Atakra Tofo and Kweku Atakra Jumo. Jude teaches, a private legal practitioner, of course, teaches the law at the Central University, and Kweku teaches at the UPSA Law School. The two of them together authored this book, Atakra and Atakra on Sale of Goods, which we shared important portions with you the last time. And just a while ago, I confessed that I have used a portion of it to make money. And which money I'm not sharing with them. Anyway, okay. I'm going to open the phone lines shortly, but I'm coming to them to see if they can get a lot more closer to tell me, when can I say, they have said it in many ways, but for your purpose, when can I say, I have come to your premises, this has happened, you say, I park my car at my own risk, but something has happened and I still insist that you must be responsible. When can I say that? And when will they say that I won't get anything if I park my car at your premises? Beyond cars, we have said a few other things. Emmanuel Hovi Posu, thank you very much. He sends us a message. First, he says, as always, very good topic, legal effect of disclaimers on premises. Thank you, Emmanuel, of the rent control. And you have also been an outstanding guest when it comes to talking about rents and what we can or cannot do. So the phone lines, as you can see on your screens now, are activated. 0302211691. Call with your questions, and if there are comments, they must be very brief. Right, so maybe I start with you.
Start with you.
Okay, maybe I start with you. So someone is listening now. He said all of the good stuff, and he's hearing the may. It depends on case-by-case situations and so on. A good number of law students and lawyers are also watching. They have a good understanding of everything that has happened from the way you have taught them. But the person who is not a lawyer, who is thinking, so when will I be able to take the occupier on, the restaurant owner or the hotel owner on, or the shop owner on, after I park my car, or the bank, after I park my car and go inside, come back and my car has been broken into? Despite the sign, you park at your own risk.
Right, so there are two levels to this. One, because I earlier mentioned that we have made provision for public, in fact, the law actually makes provision for certain commercial entities, like the banks, the shops, filling stations, to actually procure an insurance policy. So on grounds of insurance, that is one arm that you could also claim for any
on
loss.
Grounds of insurance.
On grounds of insurance.
Hold on there. Evans, you're calling us from Tamale. Let's hear you. Did I lose Evans? Okay, I lost Evans, but there's someone else's line that is beeping. Keep calling. So one on grounds of insurance.
Under the public liability policy, that requires that for public places, you are mandated to procure an insurance policy. In fact, if you look in the second schedule, it actually indicates the type of institutions. I don't think it's exhaustive anyway, but I'm sure there are more.
So the owner,
those occupiers must procure.
Must have insurance. So that you will benefit from that insurance.
Exactly, that's it, against third-party losses or damages. The second arm is basically why we are here, which we have been discussing.
Right.
And again, in terms of the second arm, where you have these notices, the extent to which they may apply, like we've already pointed out, must be in contract. Okay, and if the notices are up there, the extent to which you can rely on is whether the notices themselves are reasonable.
Hello. Just a minute. Yes, who is this, and where are you calling from? What's the name?
Vincent.
Okay, Vincent, let's hear you, Vincent.
Yeah. I'm coming from Accra.
Go ahead, Vincent.
Yeah. Yeah, I want to know something. I'm interested in the whole kit.
Vincent, is it the television by you? Put it off or stay away from it. Listen to me directly as I speak to you on the phone. Vincent, let's hear your question.
I am doing that. I am doing that.
Let's hear your question quickly, please.
Okay. If I park my car in my own premises, but it's not fenced, and somebody touches it, what is my problem?
If you park your car in your own premises,
And it's not fenced.
it's not fenced,
Yeah.
and then somebody does what?
Somebody come and touch the car.
Touch the car in which way?
Maybe you steal something from the car or you damage the car. But it's
Sounds
my own
like
premises.
burglary. Okay, thank you. Thank you. We'll attend to it, but it's actually not what we are discussing here. So you were looking at the second leg. First, you say on grounds of insurance,
yeah.
which the owner of the premises or the one in control of the premises must take. So that once you suffer the damage,
You can benefit from
can
that
benefit
policy.
from that
Because
policy.
the whole idea about that policy is for third parties.
and that is statutory.
That is statutory.
It's
yeah.
mandatory.
Mandatory, yeah.
All owners of premises.
Yes. So, for instance, Joy FM must have such policy.
Great.
Yeah.
Great.
If I'm also an owner of a commercial
Right.
premises, I must also have such
Good.
policy. And the law doesn't distinguish whether I'm a lawful or unlawful
Okay.
visitor.
Okay.
It says that commercial, that is the focus. So the focus is on the owner of the premises. The second arm is basically whether the notice which has been put out there has been brought to your attention enough, or whether the notice is also reasonable enough. Okay. And the grounds of reasonableness, we've already discussed earlier. That one, we are looking at the extent to which the notices were brought to your understanding and the fact that such notices actually existed.
Okay, hold on. Eric, you're calling from Kumasi. Let's hear you.
Thank you, Thompson. And I've really enjoyed the discussion together with your panelists. In fact, they have given us a broad understanding of the topic.
They're giving you detailed understanding of it.
Okay, should I give? Thanks for the correction.
All right.
Now, I want them to give us specific case studies.
Okay, so they have given a number of cases. They have given a number of cases as they speak.
Exactly. Like, let me give you an example. Like a visitor, for instance. If you are a visitor to probably a bank, and there is still after going in, you see the indication as you just showed on your screen. Okay, as a visitor, what will be the liability of the occupier?
Okay, that has been discussed, but we'll repeat it to you.
Whatever.
Thank you very much. That has already been touched on, but we'll repeat it to you. All right, so I don't know if you can take on from where Jude, I paused Jude, about how much attention the notice should have been brought to you, because that's where he was before, the reasonability and the fact that it had been brought to your attention.
Yes. Yeah, so we had mentioned earlier that at least the notice should have brought to your attention before you enter into the contract with the party. And I mentioned the Taunton case, which indicates that not merely saying that it's in a document, but the occupier should take active steps to bring it to your attention. So if it's in a contract, it's not merely by saying that I signed the contract. You should have pointed me to that portion and say that we have indicated that we are not going to be bound by any liability if any property of yours gets lost. The occupier has a duty to make me aware, actually.
You are emphasizing contracts. So there must be a contract before I can claim that there's a breach of something before you will now be liable. I'm driving into, a shop, and it says you park here at your own risk, and I park there. There's no contract. Is there a contract?
There's none. And that's why we're saying that. So merely putting up that disclaimer may not be enough for the occupier to say that he had put you on notice and that he's not liable. The ones the law recognizes are those disclaimers which are put in a contract. and not merely the one put at a car park saying that we are not liable. Because, as I said, the liability will be determined from the duty of care, the breach. So all the factors will be considered. The notice they put there may only amount to, as I mentioned earlier, a warning, which would be just one of the factors to determine whether the owner of the premise is liable or not. But that is not absolute in itself.
Thank you. Hello, Abbas. You're calling from Tema. Let's hear your question.
Okay. What I just want to contribute is that, you see, sometimes it's not about it. It's like there should be a security. If you park your car, that person will walk to you and then tell you this is how the situation is. Are you getting it? Because if you put this notice board there, it's like you are giving the criminals advantage to do bad things. Are you getting it? Because they know all the things back there, no one is monitoring it and no one is taking care of it. So they have access to come in and do whatever they want to do. So sometimes raising the things there is a problem. They need to have a security guard. If you pass, they walk you and tell you. If not, they are giving a criminal a time to do bad things. That is my contribution.
Thank you. So why in the first place do we hire security or guards to guard these areas?
That's a good question.
You have a security there and you still put there, you park at your own risk. And once I'm getting there is the security who is actively, or sometimes they are actually, maybe there are a number of restaurants or shops, people are actually luring you, enticing you to come and park at their end so you can enter to their place.
You see, and the comment made by the last speaker is quite instructive. And because, you see, and if we go to the only case I discussed earlier, most likely the person who went into the woman's room to steal her purse was somebody who was working from the hotel. Now, because they might have indicated that we are not liable, that's what Abbas was trying to say, that you are encouraging people to take advantage of the system. So I know that even if somebody in there steals a property, by that disclaimer, we are not liable. And that, I think, even from a public perspective, public policy perspective, is not healthy. So, one, we don't have an express legislation. That's why we are having this back and forth, because we have to rely on case law, which are persuasive.
I'll take my final call. And this will be the very final person speaking to us. Musa, you're calling from Kwau. Let's hear you. Kumbungu, let's hear you.
Yeah, Musa. I want to say that those institutions may be the approach to just putting up those notices. Because you expect me to either work from where and come to your institution to transact business. So my view is that there should be a law that will just outrightly reject those warnings or whatever we call it. Because it's a lazy approach. You know, I may either ride or bring a vehicle to the premises, and it is your duty to provide space for me by way of convenience. So
all right.
I don't know.
Thank you.
What it should be.
Thank you, but be careful. You also have a duty and an obligation, as they have explained, to be careful. You must also take certain steps to make sure that you are helping to protect yourself. Right. Okay, so that will be our last call. And we were talking about what's the use of, employing security.
Right.
So if I came to this premises and say something happened, fire, maybe there was a flood, is the occupier still responsible?
So who you came here?
Yeah, I came, parked my car there, came in here, and then there was fire. And then the thing, is bent. Or there was heavy rain, and then there was flood, and it took my vehicle away, or took my belongings away.
We'll look at everything in perspective. So we'll start from what was said earlier on.
Right.
Which is that, first and foremost, did you comply with law? Then number two, as an occupier, was the necessary environment made safe for me? And that is where we would also look at all the factors that we have.
The occupier's duty of care to you either the visitors, as in the invitee and the licensee.
Yeah. Whether I was provided in a necessary, safe environment. Yeah. So,
okay.
But if that was, I'm sure, most likely to be a force majeure. And that's if all the necessary care had been taken. Unless you have a huge flood, it probably washed away everybody's car. Maybe a force majeure. But then it doesn't take away the fact that you have a duty to take. And you see, the point must also be made. You were making a point whether the notice should be made ahead of time. Now imagine something, in coming for this program, imagine you had told us that, you know, I'm inviting you for my show, but know that all your properties are at your own risk. Your car, I'm not sure I would have come.
Right.
Because we would have thought, okay, if I'm coming to a place where my car is not going to be, there's no safety assured of my car, my gadget, I might as well just stay in the house. But most likely and reasonably, nobody will inform them ahead of time that come, but know that all your properties are not insured.
That's what I mentioned earlier, where you have been giving that warning sort of, and you still come. Then you have accepted the risk. Like you say, a voluntary non-fit injury. You have contributed to your own thing.
Yes, to that extent, if they told you beforehand, even before you came down, look, when you come, you're on your own. Here, we don't protect anything. For that, I think it's quite clear, because under the voluntary non-fit injury, you'd have appreciated the nature of the risk and the consequence of that risk. So I still say that, notwithstanding, I think that the utility of being on your show is bigger than even my gadget or my product. Then that is fine. You might have.
Imagine how many businesses would like to say that.
Exactly.
Such a thing to potential clients. Everybody wants to be in business. Thank you very much. If you have a word to say for us to close, please, let's hear that.
So what I will say is that I think it's about time we need to move away from the common law.
Right.
And try and formulate and develop laws on this particular area, especially to add on to the insurance policy bit. Because even with that, it is not too express enough to deal with these specific notices. And once we have regulation or law that would categorize on the levels of people, whether lawful or unlawful, and the kind of protection that can be offered them in terms of the duty that can also be provided, in addition to what is already there with respect to the Insurance Act. I think that would help. Yeah.
Thank you very much. I hope our lawmakers and particularly the executive is taking note, because it's important. Public law, useful to help your citizens. Yes, Jude. Kweku.
Well, I would say, as a last word, that I would add my voice to the call for there's a need to have an Occupiers Liability Act. Because, you see, we are having this whole confusion because the invitee, the licensee, the trespasser, the contractual entrance, it's quite confusing. And in fact, I mean, everybody here has read law before. Almost every student, when you give them a question even on to distinguish between an invitee and licensee, in practice, it's not too clear. And so, and it doesn't make sense. Two people enter into a place. The same harm is occasioned to them. Now we are trying to tell who is who so that we know who. It doesn't make sense. And most countries, even the UK, we follow them. They've moved from that position long ago. Kenya and the rest, they all have moved from it. So I think that there's a need for us to have an Occupiers Liability Act, which will detail or tell us who is a visitor, how a visitor should be treated. And also with this issue of disclaimer, we clearly indicate what the effect of a disclaimer is. If our lawmakers decide that disclaimers are enough to exculpate liability, then we are clear about it.
All right. Thank you very much. Jude Atakrato-4 and Kweku Atakrato-4. Jude teaches at the Central University and Kweku teaches at the UPSA Law School. They are joint authors of this book, Atakra and Atakra on Sale of Goods. I'm Samson Ladia Yenini. This has been The Law. I hope that we have given you good education. Catch you again next week.